1 in 5 women have experienced negative behaviour related to their pregnancy in the workplace, while a third of employers believe that it's acceptable to ask women about their plans for children during the recruitment process. However, under the Equality Act 2010, this would be considered discrimination, as pregnancy and maternity is a protected characteristic. But what is pregnancy and maternity discrimination? Well, it's when you suffer a disadvantage because you're pregnant, have recently given birth, or are on maternity leave. A woman is protected as soon as their employer knows, believes, or suspects they're pregnant. Legally, they don't need to be told until 15 weeks before the due date. However, as protection starts as soon as they're informed, it's recommended that you do so as soon as possible. The Act describes 2 main types of pregnancy and maternity discrimination: unfavourable treatment and victimisation. Unfavourable treatment occurs when you have suffered a disadvantage because you're pregnant or on maternity leave. However, unlike other protected characteristics, you don't need to compare your situation to someone else's. Victimisation is when you suffer a detriment because you've either made or supported an allegation of discrimination. You're protected from pregnancy and maternity discrimination during what's known as the protected period. This starts from the moment you become pregnant and ends when you return to work, either after maternity leave or, if you're not entitled to maternity leave, for example, because you are a casual or agency worker, 2 weeks after the birth. The law states that after the protected period has ended, behaviour will only amount to unfavourable treatment if it relates to a decision within the protected period. Alternatively, you could claim discrimination under another protected characteristic, such as your sex. But what is unfavourable treatment? Well, it can take many forms, including changing the employee's responsibilities, excluding them from training, or assigning particularly difficult projects in a bid to force a resignation, and is prevalent in the recruitment and promotion processes, where decisions should be made on an individual's ability to do the job, rather than their choice to have a family, with applicants under no legal obligation to reveal their pregnancy. Legally, you can be dismissed or made redundant during your pregnancy or maternity leave, provided the protected characteristic isn't the reason, and the organisation has followed a fair decision-making process. So what can you do? Well, if you experience discrimination in the workplace, it's recommended that you talk to your employer informally to resolve the situation before exploring formal grievance procedures or taking your case to an employment tribunal. All women are entitled to maternity rights, including antenatal care, health and safety protection, and a smooth return to work. Your employer must approve paid time off to attend antenatal appointments as advised by a doctor, midwife, or health visitor. They should also conduct a health and safety assessment to identify risks to you and your unborn baby, such as long hours without breaks, heavy lifting, or exposure to toxic substances. If the risks can't be removed, they should be avoided by adjusting your work conditions, offering a suitable alternative position, or suspension with pay. Before going on maternity leave, establish a regular method of communication with your employer, as they have a duty of care to keep you informed. However, they should recognise that not all births are the same, and respect that while some mothers might want frequent contact, others may not. Once your maternity leave ends, you have the right to return to your job on the same terms and conditions as before you left, with your employer holding a return-to-work meeting to welcome you back, update you on any changes, and discuss flexible working requests. In summary, the Equality Act 2010 provides strong protection from pregnancy and maternity discrimination, as women are protected from the moment an employer is aware of their pregnancy until they return to work, during which time they're entitled to several maternity rights designed to make the workplace transition to motherhood as smooth and safe as possible.